unknown fathers pled in. It is my understanding in the bench conference that Mr. Pendergraft believes that he is the father of the child. The mother has never indicated otherwise and thinks he's the dad. No one has requested any genetic testing in the case, so I'd like to dispose of that issue and dismiss our unknown fathers if in fact that is correct. So, Ms. Stevens, you've indicated that Mr. Pendergraft believes he is and wants to be adjudicated the father.
Yes, Your Honor. We spoke, and he is definitely believes he's the father, and he is hoping to keep his parental rights intact.
All right, and Ms. Mullinex, your client has not indicated anything otherwise. Is that correct?
Not that I'm aware of, Your Honor.
Then I, at this time, will, based on that information and the lack of any challenge to paternity in the case, I'm going to go ahead and adjudicate John Pendergraft as the father of Samuel Pendergraft and of Caden Daniel Creed Lewis, and establish the parent-child relationship between him and both children. Correct, Ms. Stevens?
Yes, Your Honor.
I will kick the issue about the child's surname to Ms. Stevens and her client. We'll probably at some point, we're going to have to take a break here actually for the court reporter in just a couple minutes, Amy, or not?
Sorry, Judge, I forgot to tell you, he's homesick.
Oh, okay. All right, so forget that. So whenever we have kind of our next break, Ms. Stevens, I'll let you discuss that with your client for purposes of a final order if there's going to be, a request to change the surname of the child. So I established the parent-child relationship between them and between him and both children. I will at this time then dismiss both unknown fathers that were pled into the case. And then we can go ahead and proceed with Ms. Cannell.
Thank you, Your Honor. And just as a brief preliminary matter, when we had day one, we were also coming off some inclement weather where everything had been shut down. So we didn't have all of our trial exhibits prepared. We have since filed petitioner's trial exhibits 1 through 14. The last exhibit was number 14, which was the transcript of the adversary hearing. We did receive that file and circulate that this morning. So I would just move to admit those at this time.
Are you moving to admit all exhibits?
I am, Your Honor. Thank you.
Okay, let me get those in front of me. And then, all right, Ms. Mullinex, any objection to petitioner's exhibits 1 through 14?
Your Honor, petitioner's exhibit 1 is the petition for protection with the affidavit. I would object to the hearsay in the affidavit. Specifically, there are hearsay statements made by a Ms. Kiker, Kiker, an ECI specialist named Diana, a UMC social worker named Lily, and a family friend named Cindy. I don't think that any of those people have last names in the affidavit, but I'd object to hearsay in all those. Do you want me to go ahead on the next one?
Yeah, hang on. Okay, that's on exhibit 1. Let's take them at one at a time. Mr. Groff, any response to that?
No, that's pretty standard. We'll rely also on the testimony. I understand the objection, and I'll leave it at that.
All right, so she's not objecting to the entire exhibit, but only those hearsay portions.
Hearsay statements. When I was a parent attorney, I used to make that objection, so I understand it.
All right. Anybody else have anything on Ms. Mullinex's objection?
I concur with her objection.
All right. So with respect to exhibit 1, it will be admitted excluding any of those hearsay statements. Ms. Mullinex?
Your Honor, I don't have any objections to exhibits 2 through 13. I do have an objection to 14. I don't know if you want me to go ahead with that or if you want to ask everybody else about 2 through 13.
All right. Anybody else have any objections to 2 through 13?
No, Your Honor.
No objection.
All right, Ms. Mullinex, go right ahead on 14. Well, let me just do this.
On 14.
2 through 13 will be admitted.
And Your Honor, on 14, that is a transcript of the adversary hearing. I believe under Rule 801, that still qualifies as hearsay because hearsay in Rule 801 means a statement that the declarant does not make while testifying at the current trial or hearing. So I would object to hearsay with regard to that entire transcript unless there's an exception, which I don't know that there would be an exception other than to maybe my client, some of her testimony.
All right, Mr. Groff, any response?
I mean, We have a court certified transcriptionist who's transcribing the record for Ms. Molinak's benefit. Basically, that's admitted primarily in the event there's any conflicting testimony from her client. And so any statement that the mother made in that transcript would be a statement of a party opponent. And so since she would not be objecting on that basis, I would ask the court to accept it.
It would be used for rebuttal purposes?
Potentially.
And Your Honor, I was in court this morning, so I don't know if it's the entire transcript for because I haven't seen it, but I don't know if it's the entire transcript or just her testimony, because I think that his argument works for her testimony, but not for the rest of the witnesses.
It appears to be the entire transcript.
And the only additional comment I would make is that was a court hearing on the record. She had an opportunity to cross-examine all witnesses. As I recall, the only witnesses were Ms. Cano and the mother. I could be wrong about that, but I'm relying on my recollection. And so those were all properly before the court at that time.
Well, I'm looking at the reporter's index. It appears Ms. Cano was a witness. Direct was done, was crossed by everybody. Redirect, further cross, and then Ms. Wagner, and they were the only two witnesses at the adversary hearing. So, because it is a court certified transcript, I'm going to admit Exhibit 14. Both witnesses are here or present. If there is some conflicting testimony, you certainly would have the opportunity to try to develop that and provide explanation for it or just further information. So I'm going to go ahead and admit it.
Thank you, Your Honor.
Or for the purposes of rebuttal, if that became an issue. All right, so petitioner's exhibits 1 through 14 are admitted with the caveat on exhibit 1 as to the hearsay statements. All right then, Mr. Gruff.
Thank you, Your Honor. I'd like to recall Ms. Cano.
All right, Ms. Cano, like I said, you're still under oath.
Good morning, Ms. Cano.
Good morning.
Now, since we were last in court, did you have a chance to go back and refresh your recollection on some of the matters we discussed at that hearing?
Yes, I did.
Do you recall at the first day whether or not you recall me asking whether or not Mr. Pendergraft had appeared at the adversary hearing?
Yes.
And your answer was that you, at day 1 of this final hearing, that you did not remember. Is that correct?
Yes, that's correct.
And after refreshing your recollection, would you like to change your answer on that?
Yes, he did appear, but he was late to the hearing and he did not testify.
And we've dealt with the adjudication of paternity, so I'll move on to at the last hearing. Do you recall Ms. Molinak asking you about the mother's Indian heritage acknowledgement form?
Yes.
Okay. Have you had a chance to go back and review that document?
Yes, I did.
And that's Exhibit 4, is it not?
Yes, it was filed February 19th of 25.
And on that particular form, did she indicate whether or not she was a member of or eligible for membership in a recognized Native American tribe on that form?
She had circled R on the form.
And what did you understand, if you had an understanding of what she meant by that?
I understood her answer to be no Native American.
Okay. Did you have an answer or an opportunity to discuss that with her at that time?
Yes, I did.
And so you asked her that specific question?
Yes, it's our procedure to go over the form at removal. So I did go over the form with her.
And what did she tell you when you went over that with her?
No Native American heritage.
And did she sign any other documents that also indicated they were neither members or eligible for membership in a tribe?
Yes, she also signed the caregiver resource form. And that was also filed on February 18th of 25.
Okay. And that's Exhibit 3 today. Is that right?
That's correct.
And okay. And you indicated they were both filed prior to the adversary hearing.
Yes.
Was there, and you appeared at the adversary hearing and testified?
That's correct.
Okay. And at that adversary hearing, did Ms. Wagner or her attorney dispute your testimony, that there was no reason to know the children were members or eligible for membership in a federally recognized tribe at that time?
No, they did not.
No further questions. Thank you. Ask the witness.
All right, Ms. Mullinex, any questions?
No question.
And Ms. Stevens, any questions?
No questions, Your Honor.
Ms. Sapien?
No questions, Your Honor.
All right, Mr. Groff? Further questions from Ms. Cano?
No further questions. She may be excused as far as I'm concerned, Your Honor. Thank you.
Counsel, any objection to her going on about her day?
No objection.
No, Your Honor.
No objection.
All right, Ms. Cano, thank you very much for reappearing today, and you're free to go. Have a good day.
Thank you, Judge.
All right, Mr. Groff, you can call your next witness.
Cassie Kopic, Your Honor. Thank you, Ms. Cano.
Okay, Ms. Kopic, you solemnly swear or affirm the testimony you'll give on trial today will be the whole truth and nothing but the truth?
Yes.
Very good. All right, you may proceed.
Thank you, Your Honor. Good morning, Ms. Kopic. Who are you employed by?
St. Francis Ministries.
And what is your role with St. Francis?
I'm a permanency specialist.
And how long have you been a permanency specialist?
Around 4 years.
And what is your education and training for that position?
I have a bachelor's degree, and I went through training at the department to be a caseworker.
Okay. And are you familiar with the Pendergraft Lewis family?
Yes.
How so?
I've been the caseworker since the removal.
And at that time, what did you do to familiarize yourself with the case and the family?
I reviewed the documentation and I talked to the parents.
And have you been the assigned permanency specialist since then?
Yes.
Okay. And have the children remained in conservatorship continuously since their original removal?
Yes.
Okay. And has that been more than 6 months?
Yes.
Okay. And then where was the mother living when you were assigned?
Childress?
And is she still living in Childress to your knowledge?
No.
Where has she lived since moving from Childress that you're aware of?
She went to Marshall, Texas, and then she moved to Indiana.
And what were the circumstances behind the move to Marshall and then the move to Indiana as you understand them?
Her boyfriend got offered a job in that area of Marshall, Texas. And then she also said that because she was having some health issues that she thought she could get better doctors there. And then there was an incident that happened with that person that offered the employment where they had to flee to Indiana. And that's where her boyfriend is from. So that's why they went up there, because he has relatives that they're able to stay with.
Are you aware of any other circumstances while they were in Marshall, Texas? Any investigations or any law enforcement involvement?
No.
Okay. And did the mother attend the permanency hearing on October 22nd of 2025?
Yes.
Okay. And at that time, she discussed the move to Marshall, I believe, did she not?
I don't remember exactly what was discussed.
How much contact have you had with the mother since you've been involved in the case?
About monthly. Since she moved, it's been less frequent.
As of the first day of this hearing, had you had contact with her after she had moved to Indiana?
From when we recessed this final, or
Yes.
she's had 2 virtual visits.
But I asked about her contact with you.
No, I didn't talk to her, but I've observed the visits.
Did you attempt to have contact with her?
I tried calling her, but her phone wasn't working.
Okay. Did St. Francis create a family service plan for both parents?
Yes.
Okay. And was that filed with the court and provided with to the parents?
Yes.
Okay. And what specific services and tasks were required of the parents?
So on Heather's plan, we asked her to do a psychosocial evaluation, individual counseling, mental health treatment through the Helen Farabee Center, parenting class, and then maintain a clean home because the cleanliness of the home and the mental health were the reasons for removal, and then also employment. And then the dad's service plan, we asked him to do a psychosocial. We asked him to do the batterers intervention prevention program, individual counseling, parenting, and comply with his probation because he was on probation at the time. And then housing, employment.
How much contact did you have with Mr. Pendergraft?
So when the case first started, he's out of region. So I had about monthly contact with him. And then once he got in jail, the contact wasn't as frequent, but I did send him some letters once I found out he was incarcerated, I sent him letters there and then into the prison.
And what efforts did you make to help both parents complete their service plans?
So we provided them with the service plan. We did referrals to providers. John had a courtesy worker so that he could do stuff locally that he couldn't do virtually, transportation for mom.
And to what extent did each parent engage and comply and follow through?
Heather did work some services. She completed the parenting program through Fatherhood Fire, and her boyfriend did as well. And she completed a psychosocial evaluation with Tina Souter. She did attend some counseling, but quit doing that. She did attend the mental health treatment for a little while as well, but I don't know if she's kept up with that or not since she's moved. The condition of the home, it was still the last time I was in the home, the animals had fleas, so they had a little bit of an infestation with that. But I mean, since she's moved, the courtesy worker wasn't able to make the contact with them when they were in Marshall. And then since they've been to Indiana, I don't know what the circumstances of her living conditions are. She has had employment throughout the case, but it's not been stable. And then John, he was on probation. He didn't work any of the services that we asked him to do. He had moved and then he went back to Houston, and then he's been incarcerated since approximately August, and now he's in prison.
And his incarceration, is that related to the domestic violence case that was pending at the outset of this case?
Yes.
Were there any barriers to completion of services by either parent? You mentioned dad's incarceration, but let's start with mom. Were there any barriers for her ability to follow through and complete her services?
I don't feel like there was any barriers. She had the opportunity to work the services. If she'd have needed assistance, we could have helped her. Since she's moved to out of state, then that does create barriers because we don't have contracts with providers in other states or know about the resources.
And she moved down to Marshall last autumn, is that right? Like September or October, somewhere in that ballpark?
Yes, I believe it was in October. While in Texas, she could have completed services because we do have courtesy workers that could have set her up with the stuff that's down there. But she moved.
I'm sorry, go ahead.
I believe she moved at the end of December to Indiana.
So between, let's say, October or so when she moved down there and December when she left for Indiana, what was her level of compliance at that point in time?
Well, we were doing virtual visits at that time. Her in-person last visit was in Midland in October. And then we had virtual visits set up, and she attended one in November and then a couple in January, and then she attended one yesterday.
But what about complying with services when she relocated to Marshall? During the time she was in Marshall, was she complying with services then?
She had gained employment, but that was about all that I knew about.
So she wasn't participating in any other services that you would have referred her to?
No.
And did you say she did have a courtesy worker arranged while she was down there in Marshall?
She did.
Okay. So moving to visitation, well, actually, before I do, Mr. Pendergraft, once he was incarcerated, were there any services available to him during his incarceration?
Not really.
Okay. As far as visitation, were they allowed supervised or unsupervised visitation?
All visitation was supervised because of the dad was never offered any visitation because of the domestic violence.
Right, so he was prevented with a restraining order in his criminal case. Is that right?
That was my understanding.
And the how often were mother's visits scheduled?
So we had them scheduled virtual. We would do 30 minutes 2 times a week, and then every other week would be an in-person, one in Lubbock, one in Midland.
And did she attend regularly?
She did at first. She attended pretty regularly, and then towards her moving, that was when the visits kind of didn't happen as frequently.
But it sounds like since she's landed in Indiana, she has had at least one virtual visit.
She's had, I think, 3.
Okay. Did she, when she would miss a visit, did she typically cancel or no show?
Typically no show. All of the in-person visits that she missed were they were canceled though, with whatever reason, transportation or something like that. There was one that was a no-show, but that was the one I tried to pick her up for, and I don't know, she didn't answer the door. And she called me a couple hours later, but it was already, too late.
Has she maintained any significant contact other than the visits with the children or with you as the permanency worker?
Could you ask that a different way?
Yeah, actually, I'll strike that because I think you more or less answered that question. Did you facilitate or offer assistance for out-of-state contact with the children other than the virtual visits?
No.
Okay, but the virtual visits were scheduled on a regular schedule?
Yes.
And has she provided any kind of financial support or other assistance to the kiddos?
So in some of the in-person visits, she did bring like food and stuff for the kids, but not really any like financial assistance.
Okay. Has either parent demonstrated an ability to maintain stable, appropriate housing since the children were removed?
No.
Either parent maintained stable employment?
No.
Okay. But it sounds like the mother has had some kind of employment during the time you've been involved with the case.
Yes, she's been able to get jobs, but she hasn't kept the job for a long period of time.
And are these sustainable jobs in the sense that they would enable her to financially support the children?
I would think so, yes.
She just hasn't maintained them long enough to stay in one place, it sounds like. What concerns remain do you have about the parent's ability to provide a safe, stable, and emotional environment for the children?
I think one of the concerns would be living conditions of the mom. I mean, she's out of state, so it's not like we can check her living conditions where she's at. The ability to financially support the children, also the bond that you get when you see your children regularly. I know that she's participated in virtual visitations, but it's not the same as having an in-person visit. And I know with her being out of state, that does make it difficult. And then with the dad, he's been in jail most of this time, and he doesn't have that bond with the children either. And he's also, his projected release date is March of 2027. So he's going to be in jail for another year, potentially.
And what are the ages of the children again?
2, 1.
So virtual visits, how well does a virtual visit with a young child make it so that the parent can meaningfully develop those kinds of emotional bonds and attachments?
Objection, speculation.
As I'll sustain as the question was asked. If you want to rephrase, that's fine.
I'll strike the question. Did the mother's decision to leave the state and cease regular contact create or contribute to bond building with her children?
Yes.
Did it create or contribute to any risks or instability for the children?
Speculation.
She's the
Well,
caseworker. I don't know how that's speculation.
I mean, if she knows of something, she can answer the question. Clever rule.
Can you ask it again?
Yeah. Did the mother's decision to leave the state and have some missed visitation, did that create or contribute to any risks or instability for the children?
Well, it would contribute to them not being able to see their mother and continue with that bond that they should have.
Okay. And you mentioned concerns about the condition of the home. Was that an ongoing problem in the case during your involvement?
Yes.
Okay. To your understanding, was that one of the reasons for their removal in the first place?
Yes.
Has the absence and visitation interruptions prolonged any uncertainty or emotional harm for the children?
Can you ask that again? I'm sorry.
Yeah. So you previously testified that the moves and then the missed visitation that caused harm to the ability to maintain a bond with the children, correct?
Yeah. Yes.
Okay.
And Your Honor, I actually think that's the question I objected to, and you sustained it.
No, I thought that was the question that you said if she knows, and allowed her to answer that question.
I agree.
So Cassie, so you testified that jeopardized the bond. Does that interference and jeopardy towards the bond between mother and children, does that prolong uncertainty or cause emotional harm to the children?
And
It
Your
could-
Honor, I would object to speculation with regard to emotional harm.
Right, I'll sustain as to the question as far as emotional harm.
Okay. Does it prolong uncertainty for these children?
I think it could, but due to their ages, they're in a stable environment right now and they're having all of their needs met. So I don't know that it would specifically affect them because I mean they don't know because they're little.
And let's talk about their current placement. Are they in a foster home, kinship placement? What type of home are they in right now?
They're in a foster home.
And are they placed together?
Yes.
And how long have they been in that specific placement, that specific foster home?
So Samuel's been there since the removal on 2/12, and then Caden's been there since 2/26 because he was in the hospital when
Okay.
we first removed. But
So after he was born and released from the hospital, he joined his brother in that placement.
yes,
And how are they doing in that placement?
they're doing great.
Okay. Would you say that their emotional needs are being met?
Yes.
Their physical needs?
Yes.
Do they have any special medical needs at this time?
Sammy does receive occupational therapy, and then he's getting some feeding therapy as well. But Caden doesn't have any.
And there's are the foster parents making sure that Sammy is being followed through with in terms of those special services that he's receiving?
Yes.
Okay. Is this current placement adoptive or pre-adoptive?
Yes, they're willing to keep the boys long term.
And so what are the plans for permanency if parental rights are terminated?
The current foster family will adopt the children.
Obviously, they're too young to have an opinion as to a placement. You said they're young, but I'm going to ask this question anyway. Has the parents' conduct created any emotional or physical danger to the children now or in the future?
It has in the past.
Okay. What would be the danger if the children were to be reunified with either parent at this time?
Well, John is incarcerated for assault of a pregnant person. So, I mean, with a charge like that, we don't know in the future what he would be capable of, if anything. And then Heather, I mean, she lives in Indiana, and we don't really know the circumstances of or the condition of the home. You know, the last she said she was living with her boyfriend's dad, but I mean, a change for the children to go with people that, while they are the parents, they're strangers because they haven't had that contact.
Have the parents mitigated any of the concerns identified at the outset that led to temporary managing conservatorship?
Well, when the case first started, Heather did, you know, engage in services and try to make changes, but the home was still not acceptable. And then now with her not living in the area, I mean, I don't really know what her living conditions are, but and then his circumstances are worse than the removal because he's actually incarcerated.
Had he been able to complete the batterer's intervention program?
He has not been able to complete that.
Okay. Has the father's inability and the mother's instability and failure to complete services created a risk of substantial harm to the children, were they to be returned to either parent at this time?
Yes.
How stable is the mother? We'll talk about the mother since the father is not able to have the children. How stable is the mother's current situation compared to the children's current placement?
Well, I mean, she doesn't have her own place. She's living with other people. So when you have to rely on other people to stay with them, I mean, at any point they could kick her out. And I'm not sure that she's employed either, so there'd be a financial hardship there.
So would you say the mother's living situation has changed substantially since the time of the adversary hearing versus today?
Well, I mean, so at the time of the adversary, she was also living with her friend. I mean, now she's living with her boyfriend's dad. So, I mean, other than the location of the place and the circumstances aren't much different because she doesn't have her own apartment or house or.
Have you spoken with the mother about plans she has to provide a stable and permanent home for the children?
Well, I talked to her in January and she had reached out to me because she was wanting to see if she could relinquish her rights to a woman named Misty who adopted her other child, Jasmine. And we had a conversation after that, and she said she just wasn't really in a position to where she could take care of the children at this time. I did reach out to Misty and I talked to her about that. But after talking with her, she has 5 other children in the home, and I guess some of those children are special needs. So since the kids are with people that want to adopt them, she didn't really want to break that up.
So in your professional opinion, based on your involvement, your observations, your contacts with the parent, and your knowledge of the children's needs, is termination of the parent's rights in their best interest at this time?
Yes.
And why is that?
So the children can have stability so that we don't, or they don't have to wait around for parents to be able to provide them that stability and that environment that they deserve. We don't know how long it would take. They're little right now. They shouldn't have to linger in foster care for a long period of time.
Are they bonded with the foster parents?
They are.
Okay. And if parental rights were not terminated, would that continued uncertainty or lack of permanency harm them?
I think that it
Object to
could.
speculation.
I'll sustain.
Okay. Does continuation of the parent-child relationship diminish their prospects for permanency?
Well, I mean, it possibly could, and because I mean, people move, people have to leave the state. If that would become a situation, they might not be able to stay where they're at. If the foster parents had to move to another state or something like that, I think that could, jeopardize their stability, because then they would have to go to new caregivers or something like that. But as if rights are terminated and they're able to adopt, they'll be able to stay with the family that they've come accustomed to.
And so is it your testimony today that it is in the children's best interest to have the parents' rights terminated so they can be adopted by the current foster parents?
Yes.
Thank you. Pass the witness.
Ms. Molinex?
Cassie, you said that Heather has not contributed financially to the children. Has she ever been ordered to pay child support in this case?
No.
And you said that she would bring stuff, food and things like that whenever she had the visits, correct?
Not every time, but sometimes.
And when she had the visits that you supervised or you oversaw, what was their connection? How did they interact with each other?
The visits went well. There was no issues or concerns. They got along with her well. They didn't cry or anything like that. It was a good visit.
And you said that the last virtual visit did you say it was recently?
Yes.
And she had, I think, 2 in January. Is that right?
Yes.
So she's continued to have the visits even if you haven't been able to have conversations with her, right?
Yes, she's attended some visits.
And whenever she was in Marshall, do you know who the courtesy worker was supposed to be?
I can't remember the name.
But it was a local one down there in Marshall, Texas, correct?
Yes.
I pass the witness.
Ms. Stevens?
Thank you, Your Honor. Cassie, did my client ever get an observable visit with the kids?
No,
Okay, so you have not seen him interact.
no,
So you don't know what the bond was like before this case with him and the child, right?
no.
Pass the witness.
All right, Miss,
Thank you, Judge. Ms. Kopic, one of the issues in regards to removal was mom's mental health, correct?
Correct.
And you stated that she participated in mental health services at the beginning of the case.
Yes.
Okay. And do you know when the last time she received any sort of mental health services was?
I don't know.
Do you know at any of the services she did receive if she was ordered to take, or not ordered, but prescribed any sort of medication?
She was on medication at the beginning of this case.
Do you know if she's been compliant with that?
I don't know.
And when's the last time you saw mother in person?
It was in October at that visit.
Of 2025?
Yes.
And you have not been able to view the home in Indiana.
Correct.
Have you been sent any photographs of the home?
No.
When you observed the virtual visit, do you know if she was in the home?
I don't know where she was at during the visits, but she was in a home.
But she didn't show you around wherever she was.
No, but I did not ask her to either.
And when's the last time that you've seen the boys in person?
I believe it was in December.
And did they appear to be healthy?
Yes.
No markings?
No, they were great.
And your testimony is that they're well bonded to placement?
They are.
Thank you, Ms. Kopic. I'll pass the witness.
all right, Mr. Groff, back to you. Any further questions?
No further questions, Your Honor, and no further witnesses at this time.
Does anybody else have any further questions for Ms. Copic?
No.
All right, then, Mr. Groff, you said no further witnesses?
No, Your Honor, state rests at this time, save for any potential rebuttal witnesses, but
All right, then, Ms. Mullinax.
Could I have a quick breakout room with my client, Your Honor?
Sure, and then let me just, before I send you all in there, because Mr. Pendergraft's is brought in from the unit and everything, I'd kind of like to press forward because I don't know how long they'll let us hang on to him. Is everybody okay if we work into the lunch hour?
Yes, Your Honor.
no objection.
That's fine.
Your Honor, I'm supposed to have an appointment at 12:45, but if I need to call and reschedule, I'll have to take a break.
I guess we'll see where we're at. So I'll let you talk with your client and then when we get, we'll just see where we're going to be.
May I have a breakout
Okay.
with mine as well?
So let's see. Ms. Mullinax, you could go back to 1 and I'll move him in there with you.
That would be her, my client's Heather.
Oh, I'm sorry. All right, you can go to 1 and then let me put Ms. Lewis in there. Let's see, Ms. Stevens, I'll move you to 2 and I will put your client in there with you. Let's see. Oh, gosh. You were already assigned to that room. Mr. Pendergraft, I don't know. Do you have any control over the device you're on? I'll get you to unmute for me and I may be able to talk you through this. Do you see anything at the bottom there that says breakout rooms or more?
Termination trials like this show how seriously courts weigh stability and permanency for very young children. When months pass with limited progress, inconsistent visitation, or unresolved safety concerns, the focus shifts to whether waiting any longer truly serves the child's best interest. In cases involving incarceration, mental health treatment, and service plan compliance, the court isn't judging promises. It's judging progress. And for toddlers, time matters. If you appreciate real courtroom breakdowns explained in plain language, be sure to subscribe to the channel so you don't miss future cases.